He never followed it. He never followed it.
Stop it.
I'm kidding.
I know.
In addition, and this is my own commentary here, we obviously are concerned about children.
When you're in this kind of a setting and you have the privilege of speaking in front of our audience, the temptation to tell war stories is almost irresistible.
Jimerson is a legal legend. He has every war story you can imagine.
I mean, obviously, if I'm affirmed, it's just a happy dance in my chambers. But if it's anything,
The best way to handle these cases is to win them below. Come from a position of being a respondent and not an appellant.
he is exactly right.
All right, good afternoon, everyone. Welcome to this March 6th, 2022 session of our Nevada Judges Perspective Series. You might remember back in October, we did an introduction to family law appeals, and today we are going to take a deeper dive with a wonderful, fantastic panel. We have Judge Bulla here from the Appeals Court. We also have in studio with us today Jimerson, Attorney Jim Jimerson, and then via Zoom today we also have Family Court Judge David Gibson. We will have each of them introduce themselves. Of course, we'll start with the judges, Judge Bulla first, then Judge Gibson, and then we'll let Jim go at the end there. So why don't we go ahead and introduce ourselves?
Good afternoon, everyone. I'm Judge Bulla of the Nevada Court of Appeals, and I am in Department 3. I've been on the court for 3 years, and we handle criminal, civil, and family law matters. And today we're going to be talking about family law.
Judge Gibson?
Hello, everyone. I'm David Gibson, Jr. I'm a district court judge in family court, 8th Judicial District, Department L. I filled the seat by appointment about 3 years ago and was elected then this last election cycle. We handle general family jurisdiction. I currently am assigned to juvenile dependency and juvenile delinquency cases, but for the first year and a half or so after the appointment, I was hearing the general domestic cases as well, and may in the future, who knows.
And Jim.
Well, good afternoon. My name is Jim Jimerson. My law firm is the Jimerson Law Firm. I'm a senior member of the bar. I've been practicing law for more than 45 years. And I'm honored to be here this afternoon because I'm sitting with two of the finest jurists in the state of Nevada. Judge Bola has been a discovery commissioner for many years, gotten involved in very deep and very complex litigation. Thereafter, she grew into the Court of Appeals, which is a 3-court panel in between the general courts of jurisdiction, the district court, and the Nevada Supreme Court. And she is doing an admirable job and a very difficult job because in her department, in the 3-panel cases, most family law cases are assigned to her bench. So a lot of her cases are directly facing family courts and family court issues. So her expertise, especially on issues like on appeal, is really valued by all of us as practitioners. Dave Gibson, as he mentioned, was and is a fine trial lawyer. But after doing so well in that field, he decided to try for the bench. He was successful after being appointed. I had the privilege of practicing before Judge Gibson. I've tried cases before him. He's really a stellar jurist with a really excellent temperament. How you treat people counts for something. And Judge Gibson, whether he agrees with you or doesn't agree with you, is very respectful of all practitioners. And as a practitioner, it's a privilege to practice before him. And good afternoon to all of you.
Thank you so much. And Jim Jimerson is a Nevada legal legend. So I am Alexis Brown. I am honored to be your host today for this Our Nevada Judges Perspective series about appeals. So we have a bunch of questions that we did not get to the last time that we were in studio in the Worldwide Digital Broadcasting Studios to do a session on appeals. So I'm really happy to be here. So I don't even know where to begin, I guess. Maybe Judge Bola, I guess where should we even start? We have so many questions. I know you have a lot of them in front of you. And I think last time we talked a lot about sort of when decisions were reversed, when they were vacated and remanded. What happened with jurisdiction when an appeal is filed? And then kind of, we need to know more about what happens after that, and what are some of the purposes of what goes on in the appeals court and those kinds of things. So I think there's a question here about what procedures need to be followed when a case is remanded. So of course, remanding after a decision from the appeals court, and what needs to be followed, and then what is the purpose of a remitter?
Let me start with the last question first.
Sure.
The purpose of the remitter is for the district court or the lower court to have the case back for further handling. So it really gives the court, the lower court, jurisdiction of the case so they can follow the directions of the appellate court. And it really varies case by case in terms of what those directions are. It could be that the appeal has been affirmed, which means that the lower court will simply close its case. Or we may give directions for a new hearing or a new trial. And the district court judges are excellent about following the directions of the appellate court, and they'll take that direction and move forward and handle the case.
And so you mentioned it gives the jurisdiction back because, as I think we did talk a little bit about, and I hope we will go into much more, of course, is the jurisdiction moves, basically. So first it's in the district court, it gets appealed, and then at that point it leaves from the district court and goes up to the higher courts, correct?
That's generally correct.
Generally correct, yes. Great. And then, so after it is remitted back to the district court, then what needs to happen at that point? Do the parties need to do anything? Do the judges do something? What happens after that?
Jim?
Jim?
The answer is all of the above.
Okay.
If the case is affirmed, as Judge Bola has mentioned, then largely what's going to happen is there could be a hearing called for by the court, acknowledging the written decision from the Court of Appeals or from the Nevada Supreme Court, and then the steps to implement it. And oftentimes, just like Judge Bulla has told us, it's self-affecting. So you can read the decision and know exactly what takes place. An affirmance, in all due regards, means what the judge said below counts, is now enforceable, is no longer on appeal, and is now a final order with the remitter being issued back to the trial court. If the decision is a reversal, and sometimes what you have is affirmed in part and reversed in part, so it's sort of a split decision, if you will. And when you have that kind of decision, then again, the court will likely call for a hearing, ask the lawyers involved or the parties involved, how do you read this decision? What directions do you believe that the Nevada Supreme Court or the Court of Appeals have issued to myself as the trial court judge? What do I need to do next? Let's make sure we're on the same page. There's a hearing along those lines, and then it's worked out. And the judge, oftentimes the judge will entertain very spirited arguments as to what exactly did the Court of Appeals mean. What did you mean by it?
What did you mean? Judge Gibson, if you get a remitter back in your court, what is the procedure you follow in your chambers? Or in your, maybe not your chambers, but in your court, what is the process that's followed?
Well, we as practitioners just throw up our hands.
But Jim's exactly right, that all of the above answer was spot on. I, myself, try to be as proactive as possible. Once it hits my desk, I will inform my staff that we need to get everybody contacted and set a special setting to have them come in and see where to go from there, essentially. I mean, obviously, if I'm affirmed, it's just a happy dance in my chambers. But if it's anything else, then I will do my best to keep the case moving, because I don't want the parties to languish, especially if we have a pro per or a pro se litigant as one of the parties who's received the answer. I want to make sure they're informed of what to do next.
Sure, and that was a question that we did have: is whose responsibility is it once a case is sent back to the district court? Whose responsibility is it to move it forward?
Yeah, everybody's. If you won, you want it moving, so you're going to be calling the court like crazy to get it on. And that's I like to be ahead of the game there. I don't want it to appear that I wasn't reading what the appellate Supreme Court was telling me to do. I'd rather get that case right back onto my docket and get moving on it rather than have it hold anybody up.
I think one of the things Jim mentioned, though, is important, and that is sometimes we return a case on a very narrow issue. So the entire case does not need to be retried or reheard. We just send it back so that the district court may further handle a very discrete issue. Sometimes the law changes in between the time of the appeal and the remitter, and so we want to make sure that we clearly give direction as to what the court and the parties need to do.
Exactly, and when you talk the idea of the law changing, a statute can be rewritten. You know, we have now new child support guidelines that are just rocking the trial courts. So when you have that, you have to be nimble. You have to be capable of adjusting your thinking and to try to follow the edict of the senior court.
Okay, thank you so much. Oh, Judge Gibson, it looks like you'd like to chime in. Yes.
Sure. As Judge Bulla stated, sometimes it's a very narrow issue. From time to time, it may not even require a hearing. It may be a request for a clarification of the findings that I made. We've had a lot of those, particularly in recent years in family court, where, say, in a custody decision, what's specifically addressed in the remitter is that certain provisions of the statute weren't clearly addressed by the court's order, and it may just be a direction to clarify it. And if I don't need to hear any additional evidence and I can get the parties that clarification more quickly, I'll just get right to amending my order to include those findings if for some reason they were overlooked.
And are you able to comment for us, Judge Gibson, about how it sometimes feels if you get overturned on appeal? Are you able to comment on that for us?
Sure. I've got a thick skin, and you know, my ego has shrunk over the years. I accept direction from above. I believe in the rule of law, and if the appellate court interprets something differently than I do, I may respectfully disagree with them, but I'm going to follow what they asked me to do. And so if I've been told that I decided something incorrectly, I will make a note, I'll fix it, and I won't decide it that way going forward in the future unless, as was just mentioned, the law changes.
I hear you. Thank you so much for answering that. I appreciate that. So we talked kind of about what happens when it gets back to the district court, but I do think there are a lot of remaining questions about kind of just even the appeals process and what to do when the case is on appeal and what it means when a case is on appeal. So, I mean, just at the very beginning of a case, I think some of our Nevada Judges viewers want to know if a parent in a family law case can represent themselves in an appeal. Judge Bola?
Yes, they can.
Great. And if they are, do you know anything about, can you comment on sort of fee waivers and things like that? Do you have any knowledge about fee waivers in the appellate court?
So I know one of the questions that does come up is whether someone can participate in the appeal process without having to pay a fee.
Because there's a $250 appeal fee.
Especially if they're indigent,
right,
and or have some financial difficulties. Typically, that request needs to be made in front of the district court below. So Judge Gibson would be the first one who would hear the request to proceed without having to pay the fees. However, if the district court says no, then the Court of Appeals will certainly entertain that request. There are certain types of cases of original jurisdiction which we can entertain the request before the district court does. And that would be a writ proceeding, for example.
Okay.
But otherwise, the district court really should hear the request first.
Agreed. Our firm does a fair amount of pro bono work, Judge, and you represent indigent parties. And it's a privilege to do that. For us, for myself, it's an opportunity to give back to our community and to the ladies and gentlemen of our community who find themselves perhaps unable to financially meet the costs of an appeal. And in doing that, you would file papers that essentially ask for fee waivers or cost waivers. And almost always they're granted. Now, if you reach some level of dollars, and typically it's earnings well above $10,000 a year, you could have a waiver denied. But almost all waivers are requested because in regard, you know there's a rule that requires you to, in a sense, earn less to therefore allow you to have these fee waivers. The money cannot be just given away willy-nilly. We all have responsibilities, and the court certainly does as well. But in measuring their costs, that's an opportunity that we have. And when you look at today's practice, and Judge Gibson, you see it every day, you could quote chapter and verse. And when you have more than 50% of the practice of family court on indigency, or on representing themselves, not necessarily indigency, but representing themselves and not with lawyers present, that it tells you sort of the crisis that we have. And it also tells you the patience that these judges have to have, because the counsel representing themselves have no clue oftentimes what they need to do to meet the rules and the like. So there's a fair amount of please pay attention and do a good job, and the same breath, patience and understanding.
So we've got to hear those first in the district court, and then if for some reason it does get denied by the district court, you can ask the appeals court to decide whether or not you should be allowed to waive the costs on appeal, just for the appeals part of it.
Yes, I think it's really important for the practitioners as well as the parties to understand that we are so thankful for all the professionals who take these cases on a pro bono basis. And if you take an appeal pro bono, we will set it for oral argument at the appellate level. So that encourages many of the younger attorneys who may not get the experience of arguing in front of an appellate court to take a pro bono case, particularly in the family law area, which is very helpful for everyone.
You bet it is. You bet it is. I will tell you, though, from a practitioner's point of view, in a kind of a facetious or kidding way, the best way to handle these cases is to win them below. Come from a position of being a respondent and not an appellant.
He is exactly right.
Sometimes it happens, though, right? You know, I mean, and even, you know, you're the winner, but the loser appeals. So, you know, you're still in the same position.
Absolutely.
So let's ask some questions. You know, after we have filed an appeal, you know, it is based on just the record below, right?
That's right.
So, Jim, maybe you can tell us about the role of the appendix and the transcript request and how important an appendix is.
Well, first of all, I found that you don't really need an appendix. Like my wife tells me she doesn't need a husband. So but look, you have an obligation, if you're going to take an appeal, to provide a record to the appellate court, whether it be the Court of Appeals or the Nevada Supreme Court, for a reason why they should rule in your favor, whether that be to affirm the ruling below or to reverse the ruling below. And how do you do that? Well, you can't expect miracles. You have to provide the appellate court with a record. So what is the record? Well, the record is the testimony of the men and women who have testified. The record are the documents and exhibits that have been introduced into evidence. The record can be demonstrative exhibits that can be allowed to be viewed by the court. The record can be video now. In this electronic age, everything is done by videotape and by electronic means. And so now with COVID, we've been doing the exhibit sharing or slide sharing of exhibits on the witness stand, even though you're remotely in our office or somebody else's office or even out of state. So that's very important. And the other part of it is, if you do not provide a clear record, you are bound to lose, because there's no way that the court is going to substitute its view for that of the lower court, the trial court, unless there's a clear understanding of what took place and therefore what may not have gone well or been done properly. So the record is quite important. In terms of the appendix, this is kind of a new rule some years ago. After your brief, you have 15, 20, 30 pages of briefing, and then after that you attach the exhibits that are going to support your position. Okay? It can be the entire record. It can be 500 exhibits. It can be 20 exhibits, however many there are, and you put them in index form, so you keep track of them. Typically, it is in the order in which they are introduced into evidence, and you then can provide that to the appellate court, so they're, whether it be themselves individually or their law clerks, are able to study the materials and understand what's present. And you mentioned earlier, Alexis, about not introducing things that are not presented before, not allowed to raise new things. There are some exceptions to that. Judge Bola can tell us about the plain error rule. But in the main, you're 100% right, Alexis. So you need to make sure that that which you are pointing to is well documented in the record and is defensible. And that's an important point from a trial lawyer's perspective or from a litigant's perspective.
Right, and that was one of the questions that we had was, just how important is it to preserve your arguments below, considering that it's just whatever the lower court heard, then the higher court reviews it all, or reviews some of it, or reviews, basically what you present to them, right? So how important is it to make sure you're preserving those arguments below?
Well, that's a key, and a practitioner will know, the judge will know, of a little rule that we use. It's called an offer of proof, okay? And an offer of proof allows the litigant or the lawyer, whoever the person making the arguments for, to suggest, Your Honor, you're objecting to what I'm saying. But if you would allow me, I'd like to make a short presentation about, if you allow my evidence to come in, I will demonstrate the following, okay? The car accident occurred at 3 o'clock in the afternoon. He was going through a red light and not a green light, those kind of things. And so what you're trying to do is trying to demonstrate to the appellate court, you're actually speaking to the court that's not in front of you, who will learn that if I was allowed to introduce my evidence, I could demonstrate that this was the truth and not what the judge may have found. So the use of the tool of an offer of proof is very important, because then you can tell the court, this is what is before you, and this is what, had you ruled in my view, or followed my suggestion, this is what it would have been had you allowed it to take place. And so it gives the appellate court a chance to understand, this is the consequence of ruling the way I ruled, either rightly or wrong.
So if I'm understanding you correctly, and our viewers are maybe understanding you correctly, is when you're down below in the trial court and the judge maybe denies admission of a piece of evidence, you can make this offer of proof to say, Judge, had you actually allowed me to enter this piece of evidence, it would have proved all these other things. And then that way on appeal, you can make that same argument and the appeals judge can maybe consider it.
Not only that, but you're helping out the appellate judge, because the appellate judge is going to understand this is the significance of why this is being debated.
Sure.
And then I can decide whether or not it's significant at all. Right. Maybe it's not, but at least I see it in context. I can see it, the trees in the forest.
Sure.
See how it all works together.
Sure. Judge Gibson, are you hearing offers of proof in your trials?
Yes, very frequently. I always allow the attorneys to make an offer, to make a brief statement of what their position is, regardless of what my ruling on the objection is, so that it is preserved for the record. I'm always happy to let them make a record.
Do you ever ask pro per litigants if they have a position, or do you ever try to help them in that way when you're on the bench?
Well, I can't help them,
Sure.
but I do ask them if they have a position, and I give them the opportunity to speak at least. And if as is often the case, it happens even with trained individuals. But with an untrained individual, they may start talking and wandering off course, and I will help to direct them back. I'll say, what I was asking was this. Do you have an answer to that specific question? And just so that it's clear that they were given an opportunity to understand what was going on. I'll always ask them, when they're objected to, if they have a counter position. And sometimes you get a blank stare, sometimes they have a whole lot to say, and I'm especially in the case of a pro per, I would like to make sure the record's really clear that they were given due process. They were given, an opportunity to be heard. It can be daunting to have a paid attorney on the other side there, and some people just might be like a deer in the headlights, and until you take that chance to pause and give them an opportunity to respond, they may utilize that to gather their thoughts and put something worth hearing there on the record, so the appellate court knows exactly what was going on at the time. Mr. Jimmerson, he mentioned my demeanor, but I've never seen a trial lawyer with better demeanor than Mr. Jimmerson. He does not raise his voice. In fact, sometimes I have to strain to hear, because he's not overly excitable in the trial, in the courtroom at trial, but he's always very clear, very concise, and has his citations and references ready to go. He's very good at making an offer of proof, and he's also very considerate of the other side, and will sometimes, I think, even more than he needs to be, allow them to get their, say their piece and get in it as well. There are a lot of different styles you get down there, and I imagine the appellate court has probably banged their heads against the walls a couple of times trying to make heads or tails of a particular record that's come up before them, especially on a transcript, because family court has been known from time to time to entertain a certain degree of a lack of civility and a lot of talking over one another. I do my best to kind of manage that as respectfully but as firmly as I can from the bench, because it is all about the record and making sure it's absolutely clear. I don't want it ever to go up there and have them assume I was just having a bad day and cut somebody off. I'd rather that the issues were fully fleshed in front of me as much as possible. It may actually help me to make a better decision than I initially thought I was going to make, and it might prevent the need for the appeal.
And I should say a litigant who is representing themselves, is it okay for them at appropriate times to ask you if they can make a point? I think some, you mentioned some litigants who are representing themselves kind of staring at you like a deer caught in headlights. If they do have a question or they do want to make a point, as long as they're doing it respectfully, raising their hand or something like that, so you're aware of of their intent, not speaking over, as you say, will you give them that opportunity?
Yes, absolutely. And typically, before any testimony is received or anything, even from a witness, I will try to give them a breakdown of what they can expect in the coming minutes. That they're going to have some questions from one counsel and then from another. If they hear an objection, just stop talking until they hear me rule on it, and I'll cue them that they can go ahead and speak at that point. I handle pro per litigants exactly the same way. If they're getting a little excitable and jumping in, I'll just pause the proceedings for a second on the record and say, I need you to hold your question for a minute. We're going to let the attorney ask their question or make their point, and then I'll come to you. So I do, I was a hearing master for 6 years. You have a lot of referee built in you, and a lot of it is just refereeing, just kind of helping to manage the proceedings so that you can keep the clearest record possible.
Judge Bulla was a discovery commissioner. She can talk about wrangling all day, I'm sure. So we talked about preserving the record below. Are there issues, though, Judge Bulla, that can be raised on appeal even if they weren't technically properly preserved in lower court? Tell us about that.
Yes, and I believe Jim referenced plain error review, which means we're looking at an issue that was not preserved or perhaps more plainly stated, not discussed fully on the record. We will look at those issues, but they are pretty limited in scope. One issue would be subject matter jurisdiction. Did the court even have the jurisdiction to hear the matter? And we would always look at subject matter jurisdiction. Constitutional issues, where there's due process, and Judge Gibson mentioned, the opportunity to be heard. We'll take a look at the constitutional issues to make sure the parties' rights are preserved. In addition, and this is my own commentary here, we obviously are concerned about children and the rights of children in trying to make sure that the rulings have protected those rights. But having said all of that, plain error review is very limited. It's greater in scope in some other areas such as criminal law. But for family law cases, we are pretty restricted in what we look at in a plain error scenario.
I'd like to offer a real life example. And when you're in this kind of a setting, and have the privilege of speaking in front of our audience, the temptation to tell war stories is almost irresistible.
Jim Jimerson is a legal legend. He has every war story you can imagine. Please tell us a war story,
Well,
Jim,
here's
please.
one I'm going to tell you that I had just this last 6 months involving plain error. Medical malpractice case, okay? Plaintiff suing for a botched tibia correction, okay, and a fracture. And in the course of the trial, which went on for 3 weeks, in the second week of the trial, the defense counsel introduced the subject of race. Now, how could race possibly have anything to do in a medical malpractice case, okay, or somebody's botched left tibia surgery? But in fact, that's what took place. The plaintiff had written a letter to his employer talking about, thank you for the job and the opportunity you've given me, because when I was a younger man, I didn't treat people well. And he sort of confessed to having had racist thinking or having not treated people. And he's thanking this employer for this new opportunity, sort of a cathartic new lease on life. The trial court found the comment by the defense counsel reading that plain error, ordered a new trial, okay, vacated the jury right on the spot, and just like Bonnie was saying, it's a rarity, but it was so extreme. It was so indefensible. The actions of introducing and reading that to a jury was so perverse, it couldn't be reversed with a jury instruction or the like. Now, that's also Bonnie's point, is that you don't see it in a family court very often because the trial court is given wide discretion. So they know whether or not it's meeting the order test or not. They know whether or not it's fair game or should be verboten. Okay?
Sure.
And that's why you don't see that very often in family court. But it is a subject, it is a type of a case that you referenced, Alexis, that could allow the case to be reversed and sent back.
But I think I just want to emphasize that's why it's so important to make a record.
Yeah.
Because especially when it deals with either admission or exclusion of evidence, because that review is abuse of discretion. So we really need to know what the court was thinking, and the offer of proof is so helpful to us so that we understand exactly how the court looked at that evidence and why the court either felt it should be allowed in or should be excluded. And that is so helpful. So making a record is very important in that regard.
I will tell you that in our own firm, I have a rule. Judge Gibson can verify it. You don't speak without a court reporter being present, because you never know when something's going to be said that could actually turn the case around, could change the outcome of the case. And if you don't have a transcript of it, then you're lost. So in family court, the transcript is the video record, very different than in most courts. In family law, you have the video that's on, watching us here, and then you have that transcribed into a printed word, and that becomes your record. But it's important to have that, because without that, you can't demonstrate to the appellate court what took place, where the miscarriage of justice took place, that type of thing. And so I would recommend to any litigant, whether they be representing themselves or with counsel, you must have a transcript of court proceedings that are going to affect the case, and certainly of any trial. That investment is essential. I don't care. You choose not to pay a lawyer, you might be doing yourself a favor. But the record you have to have.
Sure. And as you mentioned, though, in the family court, everything is recorded now, so it's much easier for a litigant, for instance, to get the record on appeal because there is a video of it, which is great.
That's
so
right.
That's nice. It's nice. I think a lot of the courts now are recorded, video recorded now, especially since the pandemic.
Well, particularly in family court. In RJC Civil Division, oftentimes no. Still a court reporter being taken down, or a recording tape.
Sure.
One of the things you mentioned, Alexis, also I do want to get into is a judgment enforceable while it's on appeal?
Right.
Okay, and the answer is yes. The trial court is a court of plenary jurisdiction. It can enforce all kinds of issues. So if there is a decision by the loser, whoever it was, to take an appeal, that order, that judgment is still in effect. It's still enforceable. So how do you keep it? How do you get it to not be enforceable?
Yes.
The answer is you have to petition the trial court initially, and then the appellate court following that, to get a stay of appeal, or a stay of execution of judgment. So for example, is there going to be a change in custody from one parent to another? Is there going to be an order of a payment of $10,000? Are you going to be able to stop that being executed upon or paid? So that process is called a stay. It's Rule 62 of our local rules and Rule 8 of the appellate court rules, Supreme Court rules. And that's how you kind of create a stay or a pause while you have an opportunity to have these matters heard on appeal. Because on appeal, and Judge Bulla, tell us, what is your average length of appeal now before the Court of Appeals?
Well, actually, once it is transferred, once the case is transferred to us, and let me explain that in Nevada, we have what is called a deflection court or a transfer court. So every appeal goes directly to the Nevada Supreme Court, and then by rule, they will transfer certain cases to us. Once a case is transferred to the Nevada Court of Appeals, the majority of our cases are resolved within 3 to 6 months.
You're kidding.
once the case is transferred to us. So
How long does
some
that
of
take, though?
well, it varies because there is
Wave the white
briefing.
flag.
There's briefing that has to occur,
Right.
and sometimes there's a mandatory settlement conference. So there are certain delays built into the process, but we work really hard to get our cases resolved within that time frame.
For our viewers, that's an incredible record. That is a real compliment to the judges who are handling that, because in history, it's taken much longer time.
And I think our Nevada Supreme Court has been pretty diligent in, recent years to try to make sure there's not nearly as much as a backlog, as there may have been in the past, because it is important, of course, to all of our community, right, to make sure that these orders are coming out, because it helps guide the judges. Judge Gibson doesn't, if there's new law that comes out or new decision that comes out, he's got to know about it, right? So we talked, thank you for mentioning that, of course. Can you speak to the standard that one has to, is there stuff you have to prove in order to get a stay? Like, what is the requirements in order to get a stay? Are you able to comment on that?
Yes, I am. You follow the rules, which give you certain factors, 4, 5, 6 different factors. One is the stay going to somehow create an irreparable injury to one of the litigants, okay? Is there a likelihood of success in the merits, or at least do you have a reasonable argument that your position will be acceptable to the appellate court and maybe resulted? If you're taking a flyer, the chance for a stay is probably not very good. But if you have a litigable issue, that's one of the factors that the trial court or the appellate court will consider. Judge Gibson will have an application before him. I want to stay, Judge. I don't agree with your ruling, and I need to get a stay so I don't lose the case. Well, I'm just waiting for an opportunity to brief and have the argument. And so the judge will consider the factors under these rules, which talk in terms of, well, what is the likelihood that you're going to win? Or do you have a fighting chance? Or is your case so preposterous, I can't in good conscience issue a stay? Those are the kinds of factors that the judge will consider. Does it cause irreparable injury? Am I hurting somebody by granting a stay? I may be helping you by granting it, but am I hurting somebody else, and maybe worse? And so they call these factors equitable factors that the court considers. And what harm would there be if I do grant a stay, which could be 3 to 5 months or 6 months. In earlier times, it would be more than a year. Right. So those are the factors the court has, but they have discretion. And sometimes the judge will recognize this is a close call, right, Dave? You're going to say, this is not an easy one. This is a close call. So what would you do in that circumstance? Judge Gibson, what would you do?
A close call, I'm probably going to be pretty liberal with the stay. I think if it's that close, if it's one where I even am scratching my head just a little bit, and it's telling me this is the way I think it needs to go, but this is a really good argument on the other side, I'll probably grant the stay. But I've had plenty of those too, like Jim mentioned, where you can't imagine that there's any way this appeal is going to be successful, and it's almost preposterous to think that you would hold up, especially in a family law situation, especially if it's a situation that might affect the well-being of the child. I'm not gonna grant the stay if I'm very certain I was correct and it's not got a really good chance of success on appeal. Just for the I'm confident in my decisions. So if it's a close call, yeah, it'd be a lot easier to grant that stay.
And then, so we got our stay, or we don't, maybe. Now we're in the appeals court. And Jim, you mentioned, or I think, I can't remember which one of you mentioned now, settlement process. So every case at the very beginning, when you file your notice of appeal, you have to file a case appeal statement, and you do make an indication of whether or not you think settlement is possible or not. And then I believe the Supreme Court sets it. So tell us about that, Jim.
All right. I happen to be a settlement judge for the Nevada Supreme Court.
So you know all about it.
I know a little bit about it.
Awesome.
I also was one of the original attorneys appointed about 30 years ago, now headed by Justice Ron Paragary, who's in charge of that program. But in doing that, therefore, all cases are assigned, or almost all cases are assigned to a settlement judge. Now, that can be a retired judge. It can be a senior lawyer. It can be someone who's qualified, who has had the experience and had the training to serve as a settlement judge. And what is that? That's simply to getting two parties together and recognize themselves. They're at an important point in their litigation. One has already won, and one has already lost the case. Okay? this is a new opportunity to knock off the anger and the emotion that may have preceded this moment in time, to decide, well, I have a pause of 30, 60, or 90 days to have this mediation. It gives me an opportunity to maybe sober up a little bit, get the emotion out of your brain. What can we do to resolve the case? It also allows someone who has training to, get people in a room and start beating heads. Start emphasizing, look, let's get back to what's really important. Your kids are important. Maybe your family situation, your stability in your family is important. And so that gives you a fresh opportunity to do that. And you do it at a time when somebody's won and somebody's lost. So you do know an outcome. You may disagree with it, but you certainly have had the benefit of knowing what another judge thought about the case. And if you are the loser, what you have to overcome to change the view of that judge to an appellate level. Not an easy task, especially because you hope that your trial court bench is hot, they know what they're doing, and because you have judges on appeal like Judge Bola who are respectful, know the system, and you're not going to be able to fool them very well easily.
Right. How, you said you're a settlement judge up there in the Supreme Court. How often are you guys able to settle cases? Or is it happening frequently or not? Or
my rate is about 60%.
Wow, that's really great.
And I would say most judges are in that range. I follow the statistics because if I'm not settling cases very often, maybe I'm doing something wrong. You know what I'm saying? In the same breath, so you try to keep track of that. The program is very successful. And so 50 to 60% of cases will settle at that level. And there's always been said, Judge Bulla, you've always taught me that the earmark of a good settlement is when both sides are unhappy.
Isn't that the truth, unfortunately? So once we've gone, say we don't settle, we've gone through the settlement conference process, it's not successful, now then we're briefing officially, right? And then after we've done, once it gets to you, Judge Bulla, you mentioned sort of plain error, you also mentioned abuse of discretion. Can you tell us a little bit more about, I think there's other standards, yes? Tell us about there's a ton of other standards, but generally maybe in family court cases, which ones would maybe, kind of come up?
We are looking at the law and the application of the law de novo, which means we look at it with fresh eyes. But having said all of that, so much of what we look at in the family law matters are so fact dependent. So we really appreciate Judge Gibson and the other family court judges making a very clear record on what was considered below. I also want to mention one other thing regarding settlement. If the case does not settle, we always copy the settlement judge on our decision. So the settlement judge knows exactly what happened on appeal. And I think that's helpful because it gives guidance to the settlement judges in the future. But again, we really have pretty narrow focus. The Court of Appeals is a court of error correction, which means we're really looking at what error was alleged to have occurred below, and our focus is fairly narrow. Now, we may have lots of different errors to look at, but we are very focused in what we do. And I think most of what we do really is abuse of discretion in the family law arena.
I know we're focusing on family law in the main, but why don't you distinguish between that narrow focus that you're talking about, that the Court of Appeals might be emphasizing, and the review by a Nevada Supreme Court?
So we are required to apply the law as it exists. And if the Nevada Supreme Court has made a decision, we follow that decision. Now, the Nevada Supreme Court can make the decision not to follow their own decision or to clarify it or to look at the issues again. So their scope of review is much broader, and they have the ability to reconsider a position, but we have to follow it. So we are not going to get too creative in our approach.
You're not rewriting Nevada law up there in your position.
I will say the one little caveat to that would be constitutional issues. We're always going to look at those extremely carefully. But for the most part, we have a fairly significant body of law in the family law area.
Yes, you do.
So we can apply that law and reach a decision.
Right. And the abuse of discretion standard, since it is pretty discretionary based on a lot of facts, it's pretty high to me, right? Or to overcome, yes?
We give a lot of deference to the district court or the lower courts in making the decisions, particularly if they do a good job in putting their burden of proof or allowing the parties to offer a burden of proof on the record or make a proof on the record of what they want to, what issue is before them. So again, I think there is a lot of deference given to the fact finder because on appeal, we don't find the facts. That's not our job. We're not trying to figure out what happened below. That's the district court's job.
Exactly.
So, Judge Bulla, if appealable decisions are always reviewed, but writ petitions, that is a discretionary decision to review, how would you say that impacts whether or not to file a petition versus an appeal? And can you kind of explain to us some of those considerations for litigants and practitioners as they're filing appeals and writs?
Well, writ petitions are original jurisdiction. I'm just curious how many writ petitions your office files typically, Jim?
Probably 4 a year.
Yeah, very rare. And the reason for that is it's very challenging to make a petition, a writ petition on appeal. It's a challenging issue because we don't take very many of them. And why don't we take them? Because typically an appeal is the way to resolve the issue that's subject to the writ. So if there is an ability to appeal a decision, we likely will not take it on a writ.
Exactly. What the judge is referring there is you can sometimes obviate the need for a writ by simply allowing the case to resolve by going through trial and being resolved in that fashion, and therefore the need for the emergency ruling, the extraordinary writ, is not needed because the matter goes to final decision and then an appeal is taken from one side or the other, obviating the need for the writ. But the writ is still an important process because it can involve important issues. There's one that the Nevada Supreme Court just ruled upon not 3 months ago having to do with attorney-client privilege and whether or not documents in a discovery context can be revealed to the parties or whether the privilege precludes them from being revealed. And the documents in that case may have suggested that one side was not being truthful in his or her writing. And so it would have a great emotional or visceral reaction upon the trial court because if you knew exactly what the person was thinking and the attorney-client information could be revealed, okay, in a family situation, then it has a big impact. And then that's where you get a court involved. I need to decide this now. I can't wait for it to resolve through a final resolution because the attorney-client privilege is an important part of our jurisdiction and part of our jurisprudence, and we need to have the answer now. It can't wait. So that's what makes it the challenging cases, and that's what the judges have a challenging job is. When do I get involved?
Right.
You know, when do I get involved? The Nevada Supreme Court, as Judge Bola has indicated, has a greater tendency and a greater ability to say, this is an issue that involves policy. This involves where we want the law to evolve to. And it may not apply to something 25 years ago, thus necessitating a new law. And so there's consideration that the Nevada Supreme Court has that sometimes other courts do not have.
I think there's really two things we look at in determining whether to take a writ, and that is, number one, is it a matter of statewide importance, which you mentioned, and number two, is there a lack of remedy at law? Well, if you are required to turn over documents that are privileged, you're not going to have a remedy at law because you're going to have to turn them over. So the only way to prevent that from happening is to file a writ.
That's right.
And of course, some areas are not appealable, like temporary orders, but there might be a temporary order that is going to cause, significant harm, and you need to file something with the appellate court to get some assistance. And that might be an area that we would look at in terms of taking a writ.
Exactly.
So really only majorly disruptive, majorly urgent things and majorly important things, it sounds like, kind of in really big error in order to take it before the end of the case.
The other
Otherwise-
part of it is that you're not here to step on the trial court's
Sure.
jurisdiction.
Right.
I mean,
We don't want to micromanage.
no, they don't have the time and the resources to
Sure.
do that. So they have to have some deference and faith in the trial courts, and I think with good reason they do.
Right. And then once, I mean, yeah, that's great. I mean, great to hear. I hope Judge Gibson, I mean, you're probably not getting many writs filed, I would imagine, up there.
Not many. I don't know that I think I've got maybe 6 or 7 cases that have come down with the decision one way or another. I think I was 50-50 of over 6 cases. I think I just tipped it in my favor. I just got affirmed on one.
Nice.
But I'm not being appealed very often, and
Right.
I think I've only seen a writ or 2 go that way.
Yeah.
And they are a little bit more common in the dependency and delinquency arena, just because we do have several temporary orders and different things like that in place, and we're on a really fast time frame when it comes to trials and other decisions that are made. And so I've seen them a little more frequently in the dependency and delinquency than not, but they are rare. So yeah, I don't have a whole lot
Judge
of.
Gibson has headaches far beyond that. In his dependency courtroom,
Yeah.
he'll have a male party to the lawsuit who's both the father and the grandfather. I mean, some of the strangest rulings because of
Yeah.
misconduct between parents, children, wives,
Right.
and the like. Fact patterns that are disgusting, repulsive.
Yeah.
And so he has real headaches in that regard. And so it does require a certain amount of patience and some empathy.
Yeah.
I think empathy is an important thing, and Judge Gibson certainly offers that.
No, I imagine, Judge Gibson, in the family court, you guys see so many tough things and have to make so many tough decisions that really are just to benefit the kids. I mean, that's really, whenever there's a kid involved, that's we have to make sure that they are the most well-served by what's going on. So, and I'm sure that Judge Gibson is doing that in his courtrooms, and I know that Judge Bulla makes sure that that is the case on appeal as well. So, can you tell, I guess maybe Judge Gibson, can you tell us about the law of the case doctrine and when it comes up and how it impacts a case from your perspective?
He never followed it. He never followed it.
Stop it.
I'm kidding.
I know.
The law of the case is exactly that. You know, these cases do exist within a bubble to some degree. You have previous decisions that have been made that weren't appealed or that are binding. They may have created legal fictions that govern how you're moving forward, and they're not things that you're precluded from relitigating certain things that have had a full opportunity to be litigated. So, you know, and I get direction from the like I said earlier, I get something back down from the appellate court that I may not agree with. I still am going to apply it, and it's going to be the law of the case going forward. You know, you don't look outside of what's in front of you as a fact finder. You don't investigate outside of that. A lot of the time, your rulings are only as good as the briefings that you had in front of you. You may not have seen. There may be some relevant argument that could have been made, or some law that might tangentially apply that might have changed your mind. But as time rolls on, you've got precedent within your own case you've got to follow. So
And you mean
that's how it affects me most of the time.
Sure. I mean, and you mean do you mean case decisions you made in your own case, not just decisions made by a higher court? Are you speaking? Is any of that? Is there? So you've made a decision on the, say in the first 6 months of the case, and then you hear the case later. Is that? Can you change your own mind? Are you changing your own mind?
Rarely, if I'm outside of the procedural range for reconsideration or to go back at something like that, then yeah, I'm kind of stuck by what we found earlier on. There are circumstances where there was some kind of fraud involved, or some kind of or just some kind of blatant mistake involved that needs to be corrected so that justice can prevail. But yeah, you're even you're even bound by your previous decisions. So, which is good. I don't think anybody wants a fickle jurist. I mean, you need to, you've got to be able to stick to the law and evidence that was in front of you, and decide it going forward as it goes. And then, if things change from above, they change from above, and you fix it that way. Otherwise, you're pretty much dealing with, within a bubble of an individual case. What's going on in one family is different from what's going on in another family, and the same broadly applicable law may come to two different results in those situations, and it's so fact driven, and you're making those findings and things. It's not fair to anybody to go back, for instance, when I came in on an appointment, I came in to sit for a judge who had retired early, and while she was in her absence, a number of senior judges had sat over a period of time, and there were a lot of decisions being made on cases that now were dropped into my lap that, when I looked at the decision, I may not have decided it that way, but I didn't see anything, legally wrong with it, and I was outside of the time that I could reconsider it, and I certainly would have, just as the appellate court gives me the consideration of deference to my having been on the ground and heard the facts and made the findings, other professionals who sat in the same chair before me did the same thing, and they deserve a degree of deference, and I'm not going to disturb what has been the established law of the case if it outside of a glaring error and a legal ability to make a change.
So I think that there are some litigants that have a lot of fear that even if a case is remanded, the lower court is overturned, for say that the court will still try to find a way to enter the same ruling. So, Jim, can you give advice for, people who are, looking at these decisions that come? How can they use them in their favor to make sure that they just don't feel like that they're, getting the same results, essentially? Because if they did have some success in the appeals court, they don't want the judge below then to just make the same decision, and kind of then they're back at square one again, but now it's kind of final right at that point. So what can you do with those orders to make sure that you get the most benefit out of them?
Alexis, I'm going to say your question is very perceptive. It's really an excellent question. And to me, part of the answer is I'm paid to be preventatively paranoid.
Sure.
So when I have a case coming back to the trial court, and I've either won it or lost it, I am absolutely having a semblance on what this is going to mean. Is this judge going to hold this against me if it happened to be that we were successful in reversing the judge? Is the judge going to favor me because I was on the right side? It is our job to measure that. Now, you can't get nutty about it. You cannot obsess over it. You have to recognize we all have our job to do. And I'm an advocate. My job is very different than Judge Bola's or Judge Gibson's. They have a role to play more major than my role, I believe. And so you simply have to recognize that at some point you have to have faith in the system. You have the ability, as we've discussed in other cases, to pay $450 and change a judge one time. It's a poor practice. It's a poor practice. You have to work with your judge, not ridicule your judge, work with your judge. If they care about their job, and they do, they will take the time to educate themselves to get it better. One of the beautiful things about the practice of law is it's organic. We grow together, and believe me, make mistakes every day of my practice. I try to minimize it, but it happens. So you can't get too paranoid about that. You have to react in a responsible way, take responsibility for your own behaviors. And then if you're on the lawyer side, what can I do to influence the judge to rule in my client's favor? That's my job. My job isn't to rule. My job is to encourage them to go down or make a ruling that is consistent with my client's goals.
And if now you have in front of you a decision from either Judge Bola or our Supreme Court, are you picking it apart in every possible way to make sure that the judge is doing what you want, or or trying to lead the judge down the way that you want them? I mean, what is your advice to someone, again, because I know I have seen orders, come back, and, I don't know, I mean, they're written in certain ways, and they don't always say everything, or they sometimes say things that you weren't expecting. So, as a practitioner or a litigant, are you using that to your advantage? If you can.
I don't express it that way.
Fair.
I'm not quite that jaded even after all these years of practice.
Okay.
But there's no doubt that I look at this very carefully, because the judges can change their mind just through the passage of time. They could have had an intervening case unrelated to yours, but had a fact pattern that might be directly on point, affecting this particular case. You have cases changed, new decisions in the following 6 months, a year, that you're on this particular case you're talking about, that could impact the outcome. That's what you have to be sensitive to. Sure. And recognize you're talking to jurists who put on their shorts just like we all do. You
mean we're all people? Every one of us here, even though we're on the bench too? Imagine that. Imagine that. Thank you for saying that, Jim. I really appreciate that. I believe that we've kind of covered everything that we have. I mean, do you guys have anything you'd like to add for our viewers as far as, appeals and practicing in front of your court or anything? And do you have anything to add, Judge Bulla?
I think we've really covered quite a significant amount of material today. I think if I would leave our viewers with just a couple of words of advice, which would be, number one, always take a deep breath before you file that appeal and make a decision on whether or not it's one that needs to be filed for your client. And if you do make the decision to file the appeal, make sure you have a full and complete record provided to the Court of Appeals or the Nevada Supreme Court, depending on who is going to hear the appeal. But again, I think you really have to measure your appeal, your issue on appeal. You really have to look at it carefully and decide. A very wise lawyer who I worked with many years ago once told me, never fight where you do not have to win. And I think that is a good rule to follow. But if you need to appeal an issue or a case after you've completed trial and you now have a judgment and you need to address it on appeal, you obviously need to do that. But that's why you also have the guidance of an attorney to assist you.
I appreciate that. I'm going to give David the last word on this, but I want to just simply say this. Recognize what's at stake. In the family court, we emphasize we practice a field that specializes in human misery. So getting out of the system is just as important as having entered into it. And so when you talk about taking an appeal, and even whether you're talking 3 or 6 months, as Judge Bola mentioned, or a year or two with the Nevada Supreme Court, what harm, what consequences are you causing to take? Are they more serious and more dramatic than the desire to win an appeal or win a point? It doesn't mean you shouldn't file an appeal. It simply means you need to do that evaluation. Because I tell as many clients or more that they need to get out of the system to benefit themselves, to save the dollars, the shekels that are involved in this, to save the human misery of the children and of the quarreling between spouses. And so I would emphasize resolving cases, ending cases, as much as I would espouse litigating cases.
Particularly, I would say, in the family court, in the sense, as you said, these are families. It's not just legal issues, these are families. Judge Gibson, last words for our viewers today?
Yeah, I don't know if I could have said it any better than what Jim just said. But just from a philosophical standpoint, as someone who's on the bench and is subject to being appealed, if it's a good appeal, if it's a legitimate question, I always welcome it. I don't have any hard feelings for someone that would want clarification. And frankly, I'm always looking to improve how I do my job. And if that takes some instruction from some other legal minds taking a look at the same issue and correcting some mistake that I might have made, that just makes me a better judge. So my approach to appeals and being appealed is I welcome it if it's truly something that needs to be resolved by someone above, because I think it will benefit the families that continue to come before me if I'm a better jurist you know, so appeal away, but don't make it too busy for Judge Bulla.
She's fine up there. She's working real hard, honestly. So. All right. Well, thank you guys so much. Thank you, Judges Bola, Judge Gibson. Thank you, Jim, for coming
Alexis,
today.
thank you.
Thank you guys very much. Thank you to John Stiles and Worldwide Digital Broadcasting, and to our Nevada judges for our perspective series today. Thanks so much.